Hearing the appeal, Mohan Jogie against Angela Seeley.
Milady, my lords, I appear on behalf of the...
Good morning.
Good morning, Milady. I appear on behalf of the appellant in this matter, with Miss Sian McGibbon, and Melissa Ramdial appears on the link in Trinidad. For the respondent, Mr. Keston McQuilkin, with Mr. Andre Rudder from Trinidad, and I understand that they make their first appearance before the board in this appeal.
Well, we'd like to welcome them. Thank you.
Indeed. Milady, we adopt and pray and aid our written case and make our submissions effectively in two parts. The first part is that the approach of the Court of Appeal, in the words of Justice of Appeal Jamadar, to settle the facts, was flawed, where the judge made no finding of facts to support the application of the common law doctrine of relation back. And in fact, and it's worth highlighting at this stage, he did consider it and considered that it should not apply. And so that the board has the reference for that, it's at page 230 of the record. This is the judge's judgment at paragraph 33.
This is all going to your first issue, isn't it?
This is the first issue.
It seemed to us that you could take this one quite shortly because it only goes to costs, doesn't it?
Well, it may be, Milady, but I think the difficulty is that it looks like, if we've understood the thought process of the Court of Appeal, that they identified the doctrine of relation back as potentially applicable,
yes,
and then looked at the facts to see what fact would support that. We say that that was the incorrect way to approach it, because what they in fact focused on, as far as the facts were concerned, was the notice to renew the lease. Yes. And they considered that that meant that the respondent was acting for the benefit of the estate, for the estate, and that that was all they really needed to consider. The second issue is the doctrine of relation back, which we say that in any event, the way in which the Court of Appeal approached that was flawed and was not made out on the facts of this case as properly ascertained. And when we deal with that, we'll also address the issue of the respondent's locus, which the appellant tried to raise before the Court of Appeal, but was not really heard on that issue.
But that sort of point.
Yeah.
I mean, of course, I understand the problem that you've had, but you're here now,
yes,
so let's focus on the points of law.
Very well. Well, Milady, I take the lead on that, and I'll focus immediately on the doctrine. Can I give the board the key dates, which we say are relevant to the submission? The key dates are: the lease was created on the 1st of June 1981. The lease expired on the 31st of May 2011. The notice to renew by the respondent was served, describing herself as the intended legal representative, on the 12th of January 2011. And the date that the appellant entered the property after the expiry of the lease was in January 2012. The claim was issued on the 1st of February 2012. And focusing on the issue, the letters of administration were not granted until the 2nd of November 2012. We do, of course, acknowledge that by virtue of the order the court made on the 27th of February 2012, which we'll address the board on, they considered they could appoint her as a representative of the estate. Milady, putting aside the facts for the moment, we say that the analysis of the court simply didn't justify the application of the doctrine of relation back. The sole issue in the appeal, as the board knows, was, this is the appeal before the Court of Appeal, was whether in fact the respondent was the tenant. That was in the notice of appeal, that was the argument that was made by the appellant. The respondent, in dealing with that issue in the appeal, confined its submissions to seeking to uphold the judge that the respondent was the tenant, And where it all went wrong, we say, very respectfully to the Court of Appeal, is where the Court of Appeal then considered, having settled the facts limited to looking at the notice to renew, then said that they focused on the words benefit of the estate. Now, those words, milady, we say certainly are relevant, but that was the wrong focus as far as the doctrine of relation back was concerned. And we say they went wrong in law because they didn't properly consider the principles which put a context to benefit of the estate.
So what is the right principle?
Forgive me?
What is the right principle? You say that...
We say, my lady, in a snapshot, we say that the way in which the doctrine of relation back works is that it is an exception to the general rule that letters of administration do not relate back, and that only applies, as far as we can see from the principles, to protect the estate from injury or interference. And even if a step is taken to protect the estate from injury or interference, the benefit, if there is one, has to be objective. It can't just be because the person seeking to act on behalf of the estate thinks it might benefit.
Well, surely there was an objective injury being caused to the estate if they lost the lease.
Well, we would say no, my lord, because the lease wasn't lost. The lease continued to run from 2006 right up to the 31st of May 2011, when the tenant died. There's no issue about that. We don't dispute that. The difficulty here, and we say this is where the doctrine was misapplied, it could protect the fact that that lease continued to run if, for example, in 2006, the appellant entered onto the property and said, right, I'm going to take this property for myself, it now belongs to me. That would be potentially interfering or injuring the estate because the lease continues to run. However, we say that's not the position here because the only intervention, insofar as there was any by the appellant, was following complaints by neighbours and after the destruction of the house. And in any event, his entry onto the property where he began redeveloping it came after the lease expired. There is a distinction, to answer my lord directly, between protecting something that the estate has, that is the existing lease of 30 years, and then trying to bring into the estate something which it doesn't have. In other words, to enter into a new transaction to renew the lease.
The lease has with it an inchoate right to extension.
It does.
So that's part of the estate which the deceased had at the date of her death. It was part of her estate.
It was part of her estate. She had a right to renew it.
Exactly. So
a right to purchase at half the market value.
And so the inchoate right would be extinguished unless it was duly exercised before the expiry of the lease.
Exactly.
So that's part of the assets, part of the assets of the estate to be protected by this doctrine. It's
certainly the fact that the right to extend the lease was there. We don't dispute that that is an option that the tenant could exercise. What we say is that it wasn't exercised by a person who could be recognised as the tenant.
Yes.
That's the point. And again, I hope to cut it short, milady, to deal with this point. There is a process which could, and there's no reason shouldn't have been followed in this case in 2006, right up to before the lease expired on the 31st of May 2011. Letters of administration would be applied for. The administrator would assign the lease to the new tenant. The tenant would then issue the notice. And it could all happen within a very short period of time. That didn't happen here. So although the right to renew the lease existed, it could only be exercised under the legislation by the tenant. The respondent, I think it's common ground now, was not the tenant. So she couldn't serve a notice on her own behalf to renew the lease. She also, we say, could not serve the notice as the representative of the estate until she actually had that authority by virtue of letters of administration.
So everything turns on your analysis on the meaning of the word, the benefit of the estate.
Benefit of the estate.
And you're putting forward an interpretation that would mean that even though the estate might be said to lose, on one analysis, the benefit of the lease, and therefore lose the benefit of the rights that a leaseholder would have to bring actions for trespass, you say that doesn't fall within for the benefit of the estate?
It doesn't, because what we say occurred here, my lord, is perhaps not an unusual feature. The lease continues to run after the death of the tenant. The tenant dies, lease continues to run till the 31st of May 2011, and no one renews it. Yes, you have a right to renew. Yes, you have the right to purchase at half the market value, but no appropriate person takes that step. And the legislation, which may be worth looking at, makes it very clear, yes, a tenant is defined as being a person under the contract of tenancy, but for the respondent to have brought herself within that definition, she would need to have been assigned the tenancy to become the tenant. And it's not uncommon practice, as far as we know from Trinidad, that where somebody passes away, the lease is then assigned to another person or left by will to another person, and that person may, if they wish to, exercise the rights of the tenants once they become the tenant.
When you say assigned by whom?
Well, it would be assigned by the administrator, my lord, in this particular instance.
That all goes back to requiring the person to have got letters of administration earlier on.
Yes.
So that becomes the solution.
It was always the solution, we accept. Had she obtained letters of administration early on, she may have said, well, look, with her co-administrator, I assign the lease to me, and now I issue my notice to renew. I am now the tenant.
Yeah. But sorry, go ahead.
But that makes, that then means that in fact this right to renew, it's very difficult for it to be exercised if the tenant dies shortly before the expiry of the first 30-year period. If the tenant coming up to a year or 6 months before the expiry of the tenancy, with every intention of renewing, then dies suddenly, they've lost that chance, haven't they?
Well, my lady, if the lease expires because it's not been renewed, although that may have been an intention, then that is a natural consequence of the legislation.
But you seem to be, by saying that, you seem to be assuming the answer to the question, which is, did the lease expire, or does the fact that the notice was served, plus the relation back, plus the benefit to the estate, mean that in fact the lease didn't expire? So I don't see how you can assume that the lease expired.
Well, my lady, I'm not assuming the lease expired. The basis of my submission on that is that if the lease had not been renewed by a proper person, then it would have expired on the 31st of May 2011. Of course, the Court of Appeal disagreed. They considered that the notice that was served was valid and therefore did renew the lease during the currency of the 30 years. So,
but I think my lady's point is that what you've said to us is the solution to this problem is that you get letters of administration.
yes.
Now, that might have been possible on these facts because there was a long time period. Yes. My lady's putting to you the point, let's assume it was a short period that was available. You wouldn't have had time to get letters of administration. So what you do is you renew the lease. What's wrong with that as a way forward?
My lord, we say that that's where one is dealing with a 30-year period to renew a lease, that the tenant can renew at any time in that 30-year period. They don't have to wait until 6 months before or even a day before. The tenant is in full control as to whether in fact they do decide to renew the lease or not. Here, the tenant did not, despite having the right to do so. And what we say is that the respondent, particularly in the circumstances of this case, couldn't simply submit a notice to renew unless, in fact, she was the proper person to do so. And I appreciate the example my lady has given about, well, what if there was an intention to serve it just before the lease expires? Well, my lady, we would say that that's perhaps the wrong way to look at it, because the tenant can issue this notice, for example, in June of 1981, to say, well, look, I've now got a 30-year lease. I intend now to hold this for 60 years. I'm issuing my notice now. So there's a very generous...
Notice, does the 30 years, does it start from the end of the first 30 years, or does it start from when you renew the lease? The second 30 years? It
would start from the end of the 30 years.
Yeah, so any time during the 30 years, you can extend it to 60?
Yes. There's no difficulty with that. And in fact, the legislation was amended so that the renewal could be submitted effectively the day before the lease. There was a provision for 6 months, but they said, look, you can submit it at any time. But in the circumstances that we say we've ascertained here, ascertaining the facts, there should have been no reason to serve a notice without having proper authority to do so.
How long does it take to get letters of administration in Trinidad?
It can be very quick, depending on the submission, the application that's made. And in this case, we know, for example, it was submitted in 2012. It seems to have been published in about June on the notice that's included in the record, and was granted in November. One of the things, however... Sorry.
We know that it was granted on the 27th, sorry.
2nd of November.
2nd of November. Yeah. We don't know the date upon which the application was made.
We know that the application would have been made in 2012 by virtue of the serial number that was assigned. Yeah. We don't know the precise date.
But when you say it can be very quick, what do you mean by that?
Well, if there's a sense of urgency, you would make those representations to obtain the letters of administration, and you can then say, well, look, this should be treated with a sense of urgency, and these are the reasons why, and obtain it in that way. But we also say, my Lord, there's
a limited grant as well, is there?
Exactly. This was not the only option.
What's the statutory provision for the limited grant?
There is a section in the Wills and Probate Act. Forgive me, my Lord, I'll give you the reference. It's Section 25 at page 409. Yep. We've cited it in our written case, but...
And can you also appoint a receiver, make an application to the court?
You can make an application to appoint a receiver. You could also make an application if you had wished to, and we've included an example of where this has occurred. To a grant ad collegenda bona in her favour, a limited grant just to deal with this issue.
And that is, what page reference is that?
This is the case of Abraham versus the Attorney General, where that application was made successfully, page 559 of the authorities bundle.
And within what period of time was that done?
That can be done immediately. I mean, it's really...
Sorry, what's that procedure? I'm not quite sure.
Well, these are applications that were open to the respondent to make.
So we've got the limited grant.
Got a limited...
I think you're asked about a receiver. Is that what we're now talking about?
Well, my Lord asked me whether an application could be made to appoint a receiver. The answer is yes, but that application would have to be made.
Yes.
None of these applications, of course, my Lord, were made in this case.
But what are you talking about in the Abraham's case, sorry?
It's in that particular case, the court ordered the court by order made an order that an administratrix ad litem of the estate of the deceased in that case be given a grant ad collegenda bona in her favour, and that reference is 559.
And what is that?
And that is essentially a limited grant for a specific purpose, and in that case it was for the bringing and maintaining of an action in assault and battery on behalf of the estate of the deceased.
My understanding is that the limited grant under Section 25 isn't made by the... Is it made by the court, or is it made by... because this grant is being made in proceedings which are brought. Is one a statutory authority?
Well, one is statutory, one is at common law. So yeah. I think that's, if that answers my Lord's question. The wills and probate is a statutory provision. Yeah. But there are other options, we say, that were available to her to make the application to give her authority to act. And we say, my lord, that perhaps illustrating the difficulty in trying to, in the respondent's case, that look, we can serve it without having had letters of administration on the facts of this case, because we've made the point there ought not to have been any urgency at all. There's also evidence in the record that rather suggests that before the lease expired, she knew she needed to have letters of administration and had applied for them, although that doesn't appear to be correct.
The concept, as I understand it, of a relation back doesn't rely upon discretion.
No.
What you're putting forward there are discretionary.
Well, we say these are factors that are relevant to whether, in fact, this was such an exceptional case that the doctrine of relation back ought to apply. Was there, in fact, an injury or interference to the estate that triggered the application of the doctrine or not? And we say that you cannot ignore the long delay, because if one follows the principles that we say apply, it's pretty obvious that there was no urgency, there was no interference or injury to the estate. There was a right to renew, but that right to renew was not exercised.
Well, but as my lord said, this is not a discretionary thing. Either the doctrine of relation back applies or it doesn't. And there may be other people, other relatives who will benefit from this under an intestacy, who are reliant on her having known it. So her failures or whatever don't seem to me relevant. It's for the benefit of the estate, not for her personal benefit.
Well, again, my lady, this is why I had initially thought to review some of the facts with the board, because the evidence rather showed she was not acting for the benefit of the estate. She was acting to renew the tenancy for herself and trying to acquire the land for herself. That was the evidence that was actually given in the trial. It can't depend
on the facts of this particular case. I think that's what we're saying. Either there's a relation back to validate the notice of renewal so that the lease did not in fact expire, or there isn't.
Well, and this is why we say that applying the principles as far as the doctrine of relation back is concerned, they were not fulfilled here, because there was no interference or injury with the estate that would trigger, forgive me, my lady.
No, please carry it.
That would actually trigger the application of the doctrine.
She could only get the property for the tenancy for the benefit of her children if the administrators elected to assign it to her.
Yes.
So it all had to come through the estate. The estate and the administrators would have a choice whether to give it to her or to share it between other children. So why is it not for the benefit of the estate? It comes to the executors, they can make a decision. The fact that she had this in mind, it doesn't necessarily mean that it wasn't actually for the benefit of the estate.
Well, my lady, we can only point to the evidence that we've highlighted in our case that rather suggested this was not to obtain, this was not for the benefit of the estate. This was for her to make a personal gain.
Yes, but she did give the notice in her capacity as potential.
Yes, she describes herself as the intended legal personal representative. But we say that had no legal status for the purposes of the notice, because at that time she was not the representative and she was not the tenant. And we come back to the legislation that says you've got to be the tenant before you do that. My lord, my lady.
So what's the concept of administratrix ad litem, which is referred to
in Abraham?
In Abraham, what's that?
Well, we haven't included many cases in relation to it, but essentially, applications can be made to the court for a limited grant for a person, a litigant, to carry on proceedings or issue proceedings or take action in relation to the estate of a person who's died. In this case, that application was not made, as my lord knows, and doesn't even appear to have been considered, even though it appears she was trying to obtain letters of administration or intended to at an earlier stage.
And litem presumably means for the purpose of litigation, does it?
Yes. So, for example, bringing the claim as against the appellant in this case.
I think my difficulty at the moment is you're presenting us with alternatives that should, in your view, have been, they were open and could have been easily pursued, and you're focusing on the facts of this case, which I understand. But if we're looking at this in terms of principle, we have to think of other fact situations to which it might apply. And it's not clear to me whether you're then saying, well, the doctrine of relation back could apply in other circumstances to invalidate retrospectively what has been done, or it can never apply.
Well, my lord, we don't disagree that the doctrine can apply. What we say is that the criteria, the settled criteria for that doctrine to apply, were not met in this case. Part of that, I appreciate facts are different and we're looking at the general principles, but to decide whether in fact the doctrine does apply in a particular case, you have to look at the facts that arise. And if we're right, as we say we are, that the doctrine can only engage as a protective measure, if you like, then those circumstances did not arise in this case.
Can you take us, the key, it seems to me, to your submission is that there's a distinction between protecting what you've already got, yes, and creating a new interest in land, for example.
Yes.
And can you make good that distinction with authorities?
Well, we can, and we say that the first authority... Well, can I deal with it in this way, in direct answer to my Lord's question? Could I invite you to look at the Court of Appeal's decision, which the board can find at 287 of the record.
Decision in this case?
Yes, the decision in this case. It's in a transcript. It was an extemporary judgment, yeah. Page 287. And it's at lines 24 to 30, middle of the page. And the way in which the Court of Appeal set it out was to refer to Mills and Anderson and say the doctrine of allowing letters of administration to relate back to the date of the death can only be applied where it is for the benefit of the estate. Now, we say, my Lord, that that is not a correct or rather complete statement of the law, and we say that we can make good on that if we take the board to Mills and Anderson itself, which the board can find at page 488 in the authorities. When I give the page numbers, it's the same in the electronic bundle, 488. And if I could invite the board to look straight away at the very next page, 489, top of the page. And it seems very clear that the Court of Appeal looked at the head note, which we find at the top of the page, the doctrine of allowing letters of administration, this is at B, to relate back to the date of death, could only be applied where it was for the benefit of the estate, and that therefore, since the application of the doctrine relating back would not be to the benefit of the estate, the plaintiff as administrator in that case was not bound. So that's where they've drawn that from. But what we say is, although the head note is helpful, the actual judgment doesn't support that that is the test. And if I could invite the board to look at page 494 in Mills and Anderson, where Judge Heitner, Queen's Counsel, reviewed all of the key authorities. And if the board looks at letter B, where the case of Morgan is reviewed, there are specific words that seem to trigger the doctrine. And at B, in the case of Morgan versus Thomas, it is only in those cases where the act is for the benefit, in italics, of the estate that the relation back exists. And then these words, by virtue of which relation the administrator is enabled to recover against such persons as have interfered with the estate, and thereby to prevent it from being prejudiced and despoiled. Then further down at D, citing Williams, Mortimer and Sunnox, it is clear that the title of an administrator, though it does not exist until the grant of administration, relates back to the time of the death of the intestate, and that he may recover against a wrongdoer who seized or converted the goods of the intestate after his death in an action of trespass or trover.
But isn't that just what they were dealing with in that case? It was for the benefit of the estate that they were able then to do that, but you say that they mean that it's only if they're doing that that it counts as being for the benefit of the estate.
Well, we do say, but if I may take my lady through it's a very short review, but if you look at G at the bottom of the page, again, reviewing Williams, the doctrine of relation back must be applied only to protect the estate from wrongful injury occurring in the interval before the grant. And then when he draws it all together on the next page, page 495 at B, this is where we say is a correct statement of the principle. I am satisfied, looking at all the cases as a whole, that relation back only occurs where it would be beneficial to the estate for the general doctrine not to operate. The exception applies, and this we say is the principle, to prevent injury to the estate, and in my judgment the approach should be a purely objective one.
Well, the injury to the estate was surely the loss of the inchoate right to have an extended lease.
Well, we say, sorry.
And that, therefore, that involved having to exercise the right. That's what I'm trying to put to you.
Yes, I meet it head on, my lady. What we say is that's not the correct interpretation, certainly on the facts of this case. It doesn't apply to extend a lease, which at that time the estate does not have. It operates to protect the estate, the assets that the estate does have at that time. So the right that Milady refers to, that is protected, but you need to become the tenant to trigger the 30-year extension, if that is what you wish to do.
What about the quote that you skipped over on the previous page 494 when he quotes from page 429 of Morgan?
Sorry, page 429?
No, he's quoting, in Mills and Anderson, you read out the two passages that he cites from the judgment in Morgan and Thomas.
Yes.
Which deal with wrongdoers, etc. But then at E, he says it would also seem that whenever anyone acting on behalf of the intestate's estate and not on his own account makes a contract with another before the grant of administration, that will relate back so the benefit of the contract is not lost. Now that doesn't seem to be dealing with somebody who is threatening the estate or a wrongdoer. That is the benefit of a contract entered into before the grant can be adopted.
It certainly does, but you see, this is why we said that the facts of this case, and we rely on it, whether it's an attractive position to adopt or not, that you cannot say that the person acting, the respondent here, was acting on behalf of the intestate's estate rather than on her own account. And that's why we've pointed to the evidence of her trying to persuade the appellant to sell her the property directly for half the market value by claiming that she is the tenant and stating in her evidence to the trial court that she wished the property for herself and or her children. And we say that those particular facts in this case, when one looks at E, and forgive me, my lady, I did not deliberately skip over it, but I deal with it now, we say that that's not applicable here. But if it is applicable...
I appreciate you've got that point, but are you... What do you say in answer to the point that indicates that the doctrine is more extensive than you're suggesting, and that it can create new rights as well as protecting existing ones?
What we would say is that if you're acting on behalf of the estate, that is what the evidence is. There may be, subject to the evidence, that potential application. But in this particular instance, what the judge appears to have referred to is the summary in Williams, not necessarily any authority, but when he draws it all together, and this is why I took the board to 495B, the judge says, looking at the cases as a whole, and also having considered that the then edition of Williams, it only occurs where it's beneficial for the estate for the general doctrine not to operate. And then how the exception applies is to prevent injury to the estate. Now, what
were the facts of the case? I mean, we can't just take these statements out of context. We know what situations the courts have.
Yes, and I think for the purposes of this, the head note is helpful. It's page 488. Plaintiff's son, age 16, died shortly before an accident at night when a moped collided with a tractor. Plaintiff, before taking out letters of administration of the son's estate, accepted an offer from the defendant at the sum of £375 plus expenses to discharge a statutory claim. The defendant tendered the money, but then the plaintiff refused to accept it. When the Court of Appeal affirmed the decision at first instance, Gammon and Wilson, and the plaintiff applied for and was granted letters of administration, and in his capacity as administrator issued a writ claiming damages under the Act. So the facts were different, I accept that.
So the question was whether the claim had been settled, was it, by
yes.
an offer accepted before the,
yes, the action
became the administrator?
Yes, the action of that compromise. But what we say is that when you look at the review of the judge wasn't focusing necessarily on those specific facts. He was looking to see what the general principles were and drew the conclusion that the benefit of the estate operates in a particular context, i.e. to prevent injury to the estate. And we say
he to suggest that if actually the settlement arrived at beforehand, before the grant of letters of administration, had actually been a very favourable offer which had been accepted, and maybe that had become apparent because the case had gone the other way, then the doctrine of relation back would have enabled the plaintiff to enforce that accord and satisfaction for the benefit of the estate. The problem here was that actually the administrator wanted to disown the contract. But this isn't saying that if it had all operated in the reverse, they wouldn't have been able to enforce the settlement.
Well, Milady, in the context of that particular case, This is why, I suppose my answer to that, this is why the facts of the case are important to inform what the intentions of the person concerned is for the purposes of the doctrine to apply. Because if there has been a positive, I'm trying to think of an example, but if there has been a positive step taken by someone to interfere with the estate or to take something away from it that it has, then I can readily understand the doctrine operating. But the established principles rather suggest that's not the way in which the doctrine operates. And as I recall in Mills, I don't think the doctrine did operate.
Well, at the bottom of page 495, if I read it correct, the judge is saying exactly what my lady suggested, that if it had been for the benefit of the plaintiff, if it says at the very bottom of the page, if a witness had been discovered who wholly exonerated the defendant from all blame, the plaintiff could successfully have sued upon the agreement. Is that right?
This is H, letter H.
Yeah.
Any? I think that's the submission made by.
Well, the submission is that if it works that way around, then it should work the other way around as well. That was the argument he was dealing with.
Then at B, he says the argument merits careful consideration, but I can find nothing in the two textbooks or in the cases which supports it.
Yes, it doesn't have to be reciprocal. The estate, in a way, can benefit but can't be adversely affected by the potential administrator's actions before the letters are granted.
The agreement concluded by both parents purporting on behalf of the estate was not of benefit to it.
Positively decided at letter C on page 496.
Yeah.
But whether you analyse it as Lady Arden has put it, that is protecting the right to renew, or as this authority potentially suggests, that is creating a new right, both of them are for the benefit of the estate.
Well, my Lord, what we say is that it would be a pretty significant extension of the principle in the way in which it's operated up until now, to use the doctrine to effectively make a gain for the estate as opposed to simply act to protect it, when, in the context of this case, the statute was intended to create a once-and-for-all 30-year lease, and that after that, steps have to be taken positively by the tenant if they wish to go any further. And so we say the statutory context is important here, and it may be worth looking at the particular section.
I would put that point the other way, though. I would turn it round and suggest to you maybe the proper policy is that if a tenant gives a notice, or somebody on the tenant's behalf, or whoever can give it, does give it, then there is to be an extension. The legislature has not required the tenant to go to the court and make an application, get a declaration that he's entitled to.
No.
It's simply the service of a notice.
I agree, because the legislation was intended to be simple that way. The form is actually included in the legislation. You can fill it out by hand if you want and simply say, well, look, here it is, I've given it to you at the supermarket. But the point is, the legislation in this case was doing something novel. It was effectively depriving landlords or landowners of their immediate use of the property or bringing a tenancy to an end by creating the 30-year lease. And it's worthwhile pointing out that when the legislation was passed, my lady, neither the tenant nor the landlord had to do anything. It was automatically created in June 81. But what the legislation then said is, for any extension or for any purchase, a process has to be followed. We recognise what we're doing. It is onerous on the landlord or the landowner, and so we create the machinery for that to happen. It was not automatic that you could obtain another 30-year lease. In actual fact, you didn't have to. There is an option, as my lady has pointed out, but not an option that you have to exercise. And when you look at, this is at page 402, and it's worth looking at just in relation to how the machinery would operate. This is 402 of the authorities bundle, section 4, subsection 3. In order to exercise the right of renewal conferred by subsection 2, the tenant shall serve on the landlord a written notice. And that could be done, as I say, at any time. But it's very clear as to who has to serve it, the tenant.
Isn't there a provision somewhere that says, for tenant, read assignees or successors in title?
I think my lady has in mind section,
definition in section
6.
No, I think,
Sorry.
well, I think she has in mind page 401, the definition of tenant.
Page 401.
I may be wrong.
Well, I'll deal with
I don't know
both.
what she has in mind.
I'll deal with both.
It was, I did have in mind that, plus the way that the Hector and Keith case determined that where it's talking about the benefit of the renewed lease applying for successors in title under a will or an intestacy, that also applies to the first 30 years of the lease.
But once the lease is current, my lady, yes, you can pass it, if that's what my lady was asking. The lease is transmissible on death, once there is a valid lease in existence. But what I thought my lady was asking was about section 6, which is at page 405, which makes provision that where a tenant has an option for renewal and exercises that option, then the rights and obligations of both inure for the benefit of and are enforceable against executors, administrators, assigns, but no further. I thought that's what my lady may have had in mind.
It was a combination of the two
Right.
provisions.
Then if I can go back to my Lord Legate's reference at page 401, the definition of tenant, and this is why we say that the respondent could not bring herself within this, as appears to have been accepted. Tenant is a person entitled in possession to land under a contract of tenancy, whether express or implied, and whether the interest of such person was acquired by original agreement or by assignment. The point being, the tenant, whoever that person may become, can exercise the right to renew. Once that's done, it inures for the benefit of the estate. We have no difficulty with that. We don't say that that is not the case. But what we say is that you have to become the tenant. And whatever else may be said, the process by which you do that...
And that means you have to become entitled to possession of the land.
You have to.
That's the definition.
You have to be. And the board has considered it in a different context. In the case of Gopal...
Just before you go there,
Sorry.
Before we move on and lose the point, I was interested as to your explanation of the statutory purpose. Did I understand you to say that prior to 1981, there was not this renewal process, and that the 30 years would be what, automatically?
No, prior to 1980, sorry, prior to the, forgive me, my lord,
Yeah.
prior to 1981, there was no equivalent provision.
Right.
In fact, the position in law was under the Rent Restriction Act, which was very similar to the Rent Act in England. This was designed to protect the chattel house, which had now become a much more substantial structure for those who were land tenants.
Right. And the renewal process was there from day one, was it?
Yes, that has always been there, except that there was one change by the legislature in 2010, which said that you had to, the original legislation, you had to serve your notice 6 months before expiry, and then they removed that and you could serve it at any time before expiry.
Right.
That was the only amendment to that section.
Yes.
Is it a convenient, sorry, go on. I just want to say, I just wanted to, at some stage, ask whether you could deal with another hypothetical. And if you go back to the case we were looking at, Mills,
Yes.
if the action of accepting the compromise without the appointment of an administrator had been by a solicitor and not by the person who ultimately becomes an administrator, would you have any submission on whether that could be enforced?
Well, my lady, yes, is the short answer. I do have a submission. The difficulty with all of this, with accepting that another person other than the tenant or a representative of the appointed tenant issuing a notice to renew, is fraught with difficulty for this reason. If, prior to letters of administration being granted, the appellant, in this case, as he was invited to do, said, okay, I accept the notice from you, but someone else is then appointed administrator and someone else is appointed the tenant. The position of the landlord is compromised because he's accepted a notice from someone he shouldn't have accepted it from, someone who's not authorised.
What is the...
If Milady, in this case, the attorneys had served the notice, which they did, and they were acting for the respondent, but the respondent then did not become the personal representative or did not become the tenant, the landlord is then in difficulty again in even accepting that. If someone else who's been properly appointed comes along and says, well, look, I've got letters of administration, it's now been assigned to me, I am now entitled to this property.
What?
The landlord's... Sorry. I'm trying to answer my lady's question. And this problem, we say, is a major practical problem for landlords in Trinidad and Tobago, because if you don't have the proper person issuing the relevant notice, the landlord could end up saying, well, you've come along, you say I'm acting for the estate, so I'll accept what you have provided. But then what if that person doesn't become the representative? What if that person doesn't become the tenant? If, for example, the landlord in this case, as you've seen from the record, had acceded to the respondent's request, I would like to purchase this property for half the market value. The papers are drawn up and the land is transferred. Someone shows up later on and says, well, look, but I'm the tenant. I am the person who's entitled to purchase at half the market value. I have an action against you. And so when one looks at the doctrine of relation back, we say that those practical considerations also apply, because when you look at the way in which the tenancy is recorded, none of the contracts of tenancy from 1981 or prior to have been available. I've certainly never seen one that has survived under this legislation. But the process has been that you purchase the land, and on the deed it is endorsed that there is a land tenant on that property. And that occurred here. And I draw this to your attention because if you look at page 47 of the record, you'll see that that is the way in which it was recorded in this case. This is bottom of the page, page 47 of the record, that on the conveyance of the freehold of the property, it was subject to the existing tenancy of Cynthia Abbott. But beyond that, there is no way to know who behind Cynthia Abbott may wish to make a claim. That's the only information available. And that practical problem showed itself in this case, because after the tenant died in 2006, the property does not appear to have been cared for. Certainly it's agreed that the appellant had to clean the property in early 2011 because of complaints by neighbours and the health authority. But looking at the deed, he is the only person you could identify as a person having responsibility. Nothing is done by the tenant or a person who may succeed her to look after the property, to act for the benefit of the estate. It's left to the landlord.
Presumably there's some rent payable.
Then, again, but that rent has to be paid.
And the question is, if you received a notice from somebody who's not the administrator but hopes to be, how long do you have to wait around if nothing happens when there's nobody to enforce against the obligation to pay rent or all the other tenants?
Exactly. And an additional problem arises. If you accept rent from a person who is not the tenant and may not become the administrator or becomes the tenant, if you start accepting rent from that person, are you not at risk of potentially creating a new tenancy of some sort? Because you're accepting rent from this individual, says, well, look, I have rights and you're taking the rent. You are now my landlord. How long does the landlord, if you like, wait in the wings to know, is it going to be renewed by a proper person? Is it going to be purchased? Is it not? The only thing he can look to, because there is an absence of a written contract or a person who's the successor. The only thing he can do is look at the dates, which is why I gave the dates to the board early on, the 31st of May 2011, because it's only at that stage, if no one has made a application or become the tenant, the lease has then expired, and he acted on that. And we say he acted correctly on that because it was the only certainty in terms of, it was the only certainty he had. It had nothing to do with the respondent or whether the respondent could or may have become the tenant or administrator. He couldn't rely on that, and he would be ill-advised to do so, because what if she didn't become the administrator or didn't become
the answer to that the person who does become the administrator can decide whether the actions of the previous person are for the benefit of the estate or not, and if they are, then they can be, the relation back doctrine can apply. I mean, what happens if the potential administrator serves the notice and then dies herself? That can't then lead to the rights evaporating.
But how long does the landlord, who is the freehold owner, wait?
Well, I don't quite understand your points about delay. I don't see any cases which suggest that the time lapse between the action, which may or may not be for the benefit of the estate, and the grant of the letters of administration is relevant to the question of whether relation back occurs. Can
Milady,
you show us a case where it said, well, sorry, it was all too long between what you did and the letters of administration?
Milady, may I deal with it in this way? Can I take the board, in direct answer to my lady's question, to the principles that we say are established and apply, and do apply in Trinidad? And that may, I hope, give the answer to that question. So I've taken the board to Mills and Anderson. I rely, as the board knows, on page 495 at B, which we say settles the principle after the review of the cases. But it's not the only case. There is the case of Caudle. And if we go to page 504, this is a decision of Justice Wynne Williams in the Queen's Bench Division. I would draw the board's attention to page 504, paragraph 32, which is at E to F, where the judge cited the extract from Sherwin and Bonehill. The powers of an administrator to act before grant are exceptional and limited in effect to essential actions to preserve and protect the deceased's estate. He noted no authority is provided for that proposition, but as it seems to me, it would be an extraordinary state of affairs if that were not so. There's an additional point which I deal with now, so I don't have to go back to it. It's page 505, top of the page, citing Bowler versus John Molam. Authority for the proposition that if a claimant brings an action in a representative capacity as administrator, then that action is a nullity if he was not at the date of action, was commenced an administrator with a proper grant. And we say that that applies here, and I will touch on it, if I may, towards the end of my submission. But it goes on to say that as far as the Mills and Anderson case was concerned, which the judge considered, he considered it didn't assist in the issue that arose in that case. But the consistent theme, as I say, if we'd now turn to Long versus Burgess, my lady was asking the question in the landlord and tenant context, and this, we say, is directly relevant. If I can invite the board's attention to page 512, and it's the point I make about delay, and we say that this supports the position of the appellant in this appeal. It's middle of the page, page 512, where the King's Bench Division there, it is quite true, middle of the page, that the son or daughter did not think of applying for letters of administration during the hearing of the case before the county court judge, But surely, if they had done so and succeeded in obtaining a grant, the grant must be taken of only such property as the intestate had at the time of the grant, and cannot be taken to include a right of property which had been validly extinguished or transferred. And then 2 pages on, same point, page 515, middle of the page, second paragraph, 3 lines in, it seems to me there is much force in the contentions advanced for the landlords that the doctrine of relation back must not be applied save to protect the estate from wrongful injury occurring in the interval, of which in this case there was none, that a title cannot relate back if it is a title to something which has perished or been extinguished without fault or wrong on the part of anyone in the interval, that the principle of relation back cannot be applied so as to invalidate interests lawfully acquired in the interval. Now, my lady, pausing there, we say that when one looks at the approach adopted in that case, it does have a direct bearing to what took place here, because the doctrine cannot operate to, if you like, resurrect something which has extinguished. And if we are correct that the notice was not served by a proper person, then that lease was not renewed. And it's not the fault, I hasten to add, of the appellant that that is so.
Is there any time limit on how long after the death you could take out letters of administration?
There is...
I mean, because until that's done, if the landlord, seems to me, if the other case against you is right, the landlord's faced where there's a sort of optional lease, which either exists or doesn't, depending on what someone chooses to do in the future.
Well, yes, but I think the problem is the way in which I think the answer to my Lord's question, the way in which the Wills and Probate Act has operated includes Section 10, which rather suggests that someone has to act pretty urgently to obtain your letters of administration or to prove your will. This is 407 of the authorities bundle.
Well, if he'd gone into possession, would it not be a question of prescription?
Forgive me, my lady.
If the landlord fails to do anything, obviously he can't then say he's prescribed against any potential claimant of the land. But if he went into possession as here, he would have to wait till the expiry of the period of prescription, would he not?
I don't think so, my lady. The legislation, having been put on a statutory footing, as long as the lease expires, it reverts to the landlord. I don't think there's any prescriptive right that would arise in this particular instance.
I see, yes, thank you.
I hope that answers the question. But Section 10 of the Wills and Probate Act creates a summary offence, but the relevance of it is that it doesn't permit possession of or dealing or administering an estate without proving the will, or, in the context of this case, obtaining administration of the estate of the deceased within 3 months after the decease of such person.
But that didn't happen here.
No.
But you can still get valid letters of administration after the 3 months.
No, that's right. I don't think you can say this section prevents you from getting it. That's not the position at all. What I'm saying is that there is a sense of urgency that if you want to deal with the estate, Parliament has seen fit to say, well, look, you
that's
should do so
encouraging.
urgently.
But what I wanted to know is, there does come a time when it's too late, or does that never happen? I mean,
I don't want to say there's ever time it comes too late, because there are plenty of cases where letters are applied for much, much later, or weren't applied for at all, and then there have had to be applications by 3 people who've died one after the other, and they try to do it all together. I think the difficulty, or rather the argument we make, is that before you can deal with the estate, whenever that is, you've got to be properly clothed with authority to do so. And so
sometimes there can be disputes, can't there, as to who is entitled and who should get the letters of administration, and those disputes may take some time to resolve. So what happens then?
Well, I think I would answer that question. What happens then? But what happens to the landlord then? Because does the landlord have to wait and not do anything, even though the lease has expired, nobody's been appointed? How long should he wait?
Well, the lease, you say, has expired, but he has been given a notice to renew it for another 30 years.
Well, I think and then we come back to, is the notice valid?
Yes.
And this is why we say it can only be valid, and I'm sorry I've come back to it, but the legislation is so specific. It says, look, you've got your automatic 30 years, but if you want another 30 years, there's a certain process you have to follow. That process has to be followed by the tenant. It wasn't followed in this case by the tenant. And that's why we say that legislation depriving the landlord of property has to be followed strictly. And we say that the board has already adjudicated on that to say that that is the approach to be adopted. And if I can invite the board, just before I go back to this is...
When you say this process has to be followed, but we can all think of hypotheticals where it would seem really very harsh. I mean, if somebody's killed in a road accident, what happens then? You're positing, oh, this tenant had plenty of time, should have dealt with it, and so on and so forth. But we can concoct situations where that's just not going to be applicable. Although
I would seek to persuade my lord not to give the hypotheticals or to concoct an example and remain looking at the facts of this case. I'm suddenly reminded of I think it was Baroness Hale said that sometimes hard facts do make hard cases or something along those lines. But in this particular instance, if I can answer my lord directly, there are always time limits, are there not, to take steps to preserve assets, to probate a will, to renew a lease. Those things are prescribed. Sometimes it is simply a hazard of life that the expiration occurs and a step has not been taken within the requisite time. And there are plenty of limitation cases where someone comes after the limitation period has expired to do a thing and are told, well, I'm sorry, you may have had a good claim, but you're out of time to do it. In the context of this case, you have a 30-year lease, you have 5 years, in effect, from the death of the tenant to take action. Surely, looking at the facts of this case, to the extent that they provide an answer to this, you cannot say that the appellant was at fault in not acting on a notice that was issued by somebody who was not the tenant. And if, in that
instance, he took the risk.
If he had taken the risk and said, well, I accept it, and I as I said to my Lord Legate, what if that person doesn't become the tenant? There are major problems that would arise for the landlord in acting, dealing with somebody, dealing with the estate, who's not authorised to deal with it.
Well, if he's in doubt, can't he himself start proceedings?
Is it necessary for the landlord to do that? Is it reasonable to put it on the land? I'm sorry, I'm answering a lady with a question. I would say that it's not reasonable to put the landlord in that position because he is only subject to the lease under the Act.
This is a situation where the tenant has not, where no action has been taken. Some action has been taken. So you're on notice of that. And you still, I don't think, have answered my question about what if the attorney or some agent of purportedly thinking they're an agent acting on behalf of an administrator, does take some steps, and that person, the administrator in that example, is not the person ultimately appointed, somebody else is appointed, but the administrator who is appointed said, yes, I agree with what the administrator did, and I adopt that, what the attorney did, and I adopt it.
I think if you have a person acting as agent for the appropriate person, so let's say the tenant, Cynthia Abbott, instructed her attorneys on her behalf to serve the notice.
That would obviously be all right. Yep,
that's fine.
But we're contemplating the situation she's passed, and we're now talking about somebody else serving the notice on behalf of the administrator. But they make a mistake for one reason or another. They didn't realise this person was not appointed.
Well, I think, sorry.
The person who is ultimately appointed adopts and ratifies what has happened.
If there's ratification, there's no difficulty, but time then becomes relevant because when would that ratification occur? How long does the landlord have to wait? And what we say is that it is time sensitive. it is time sensitive to take those actions prior to the expiry of the lease. And in modern litigation, we would say, my lady, in answer to that point, that it should not be difficult for all of this to happen in a day, perhaps even the day before the lease expires.
But we all know of administrations where it's not actually been appreciated that there were assets in the estate which needed administration.
Of
you
course.
may have to wait 20 years before we get a grant of administration.
But then...
in the example I've given, you're accepting that ratification works backwards retrospectively, and that applies, does it not, even to something which is a nullity. You can ratify a nullity with the effect that it becomes a legal fact with legal significance.
I don't think you could ratify the nullity in relation to the issue of a claim, if that's what my lady had in mind.
There's authority for that, namely Danish Mercantile and Beaumont in 1951, where the court liquidator came in and found that a person without authority had started proceedings, and the proceedings as they then stood were a nullity. The court accepted they were a nullity, but the liquidator coming in later could ratify them and therefore avoid an order for costs.
But in that case, as I recall, the correct process was followed for appointment and ratification.
Well, you've got a duly appointed administrator at the end of the day. There was a duly appointed liquidator at the end of the day.
Yes.
But the proceedings had become a nullity. Nonetheless, he could ratify them.
Where you have well, I'm not familiar with the details of the case.
No,
I do recall it, but I think that if Milady is saying that there is a process which, if followed correctly, can ensure that a proper claim is brought, I don't think we have a difficulty with that. But as I will show, in this particular case, the claim was not actually, although the respondent was appointed a representative for the purposes of the claim, in actual fact, it was a nullity, and when you look at the rule under which she was appointed, she couldn't have been appointed as a representative of the estate anyway.
But then we go on in time, and she and her brother become the administrators de jure.
Yeah. But I've almost lost my place. I'm coming back to it.
I'm sorry.
But, no, it's quite all right. It's my fault. Page 515, I think I've, in the authorities bundle, this is the position of the landlord. I think I've taken the board to this in relation to how the doctrine would operate.
The end of that paragraph is significant when he says it, to apply the doctrine in circumstances which those of the present case leaves the landlord, it may be for years, in a position of intolerable doubt as to his rights.
Yes.
For instance, whether he can safely re-enter and deal with the property.
Yes, I think I read the first part. I haven't got to the
point is that you can't have to wait for 20 years to find out whether there's a tenancy of your land or there isn't.
Yes, and
depending on what somebody decides to do in the future.
Exactly, and the other difficulty the landlord would also face, remember he's the freehold owner. Who is paying the land taxes? Who is paying the water rates? All of which, if you do not pay, as far as Trinidad and Tobago was concerned, could potentially encumber your title. So what action can he take? And we say that he delayed.
Add to that, if somebody purported to act on behalf of the estate and they entered into, or purported to enter into a bargain which wasn't for the benefit of the estate, it was on bad terms, well then subsequently they could turn up. Even if they were appointed administrator, they could turn up and say, oh, well, we didn't like that.
Well, that's why the landlord needs to deal with a person who's properly appointed.
Yeah.
But going on, it gets, we say, stronger for the appellant, because if you look at the case of Smith and Mather, which was cited in Long, if you go to page 520, the point about uncertainty for the position of the landlord is underscored. It's bottom of the page, about a third of the way up. Nobody at that moment, this is when someone passes away, nobody at that moment can know whether letters of administration may not be taken out. And on any view, as it seems to me, the landlord who wishes to bring an end to a contractual tenancy which is subsisting at the time of death ought to be able to serve a notice to quit in order to bring it to an end. And this was a service on the equivalent of the Administrator General in England. In this case, we say that in any event, if we're right, the lease expired in May 2011. So if that has occurred, and the tenancy has determined, the landlord remains in uncertainty if he has to wait before he re-enters the land to see if anybody pops up with letters of administration. We also say that in relation to this particular legislation, and I insert this now, if my lord goes, my lady goes to page 452, forgive me, page 459 of the same case. It's Gopal versus Baksh. Top of the page, page 459. And this, I hope, deals with, I think it was my lady, Lady Rose, who asked me the question, but what the board emphasised, dealing with Section 16, is that the creation of the 30-year statutory lease is a once-and-for-all creation. And for the future, a tenant has to look after his own interests. And that is why, having looked at the section for renewal, not any old person can issue the notice. It has to be a tenant. And although the tenant enjoys full benefit and protection of a 30-year statutory lease, the renewal doesn't fall into the same category. That is something that is optional and may not be applied for. But if it's going to be applied for, it has to be applied for by the relevant person. We also say...
Where did you get that from?
Well, part of it is argument, my lady. The other part of it, this is the top of the page, the once and for all character of the creation of the lease, page 459, top of the page.
Yeah.
Yeah. And what Lord Walker was emphasising is that the creation of the statutory lease, the automatic one in 1981, is once and for all. But for the future, it rests on the tenant to look after their own interests. So if they're going to renew, no difficulty, they must do so within the machinery provided by the Act. And we say that, again, in support of the appellant in this case, if the board looks at the decision of Ramdas versus Bahor Nanan at page 450, and why we emphasise that the appropriate person has to serve the notice, top of the page, last 4 lines, a statute which deprives landlords of property rights must be construed with some degree of strictness. And we rely on that in support of the argument that if...
Sorry, page 4...
This is page 450.
Yes, sorry.
First paragraph, last 4 lines. A statute which...
What paragraph are you...
Page, paragraph 24.
What case are you picking this out?
This is Ramdas Nanan, my lord.
So it's page 450, paragraph...
Of the authorities bundle, paragraph 24, last 4 lines. Sorry, I should have...
Is that talking about this Act?
Yes.
Yeah.
This concerned the same piece of legislation. Now, so that I don't exceed my or run out of speaking time, can I give the board these same point on the doctrine? I've taken the board to Smith and Mather, page 520, so that the board has the reference. That was applied in Long versus Burgess, page 512, and I've taken the board to that. But then when we go forward, as far as those cases concern Trinidad, you can see the position adopted in Trinidad and Tobago, which is consistent with the approach in those cases. And we start with the case of Arthur versus Gomez, which the board will find the relevant part at page 525. This is a decision of Chief Justice Hugh Wooding, 1966.
So what page do you say?
Page 525. And it's bottom of the page, beginning with the words, reference was made to the doctrine of relation back. And it applies the case of Long, which I've taken the board to, and says that for the title to relate back, it must be a title to something in esse at the time of the grant. A lease extinguished in the interval between the death and grant is, in this respect, in just the same position as a chattel lost or destroyed in the interval. The title cannot relate back, for it is a title to nothing. The doctrine of relation back cannot breathe new life into a corpse. And so, maintaining the argument that the lease expired because it was not renewed by a proper person, the fact that it has been lost to the estate, although the beneficiaries to the estate may have a sense of grievance, that is, I'm afraid, a consequence of the lease expiring. It's certainly not the fault of the appellant to have, or any action on the part of the appellant that creates that difficulty. And so to effectively reverse the principle or apply it in a way that would allow a lease that has expired, not having been renewed by a proper person, to now come back to life, we say is plainly wrong. That brings us, my lord, to, my lady, forgive me, in relation to the doctrine, we've taken the board to those principles. I hope I've now covered the main ones. They are in our printed case. But what we say it shows is that the doctrine cannot be used to validate these notices as the Court of Appeal did. If the appellant had done something to interfere with the estate or prevent, for example, the notices being issued, that might be a different matter. He has done nothing like that. He has entered onto the property which he owns. He's the freehold owner after the lease has expired. It could not be right for the Court of Appeal to have then applied the doctrine in the manner in which it did. And we do maintain that it was not even open to the Court of Appeal to have done that, and we'll deal with section 39 from A at the end. But the doctrine has never operated, as far as we can see, and positively said not to operate, to resurrect a lease which has expired. And if that has happened by a fluxion of time, then that is, I'm afraid, a natural consequence of the finite nature of a 30-year lease. And although I take on board what my lady and my lords have, my ladies and my lords have said about renewal and benefit of the estate, but the principle doesn't operate merely for a benefit. It operates to protect the estate from injury and interference. And so unless the respondent could have shown, which she could not show, that the appellant had somehow interfered with the estate, the doctrine could not have been applied to deal with a totally different point of validating the notices to renew the lease. And there's certainly no case that we can find that would permit that, certainly by bringing an action that came so late in the day. And we turn to that now. But before I do, my lady, would you like me to address the doctrine any further? Because I'm going to turn to the claim now. There is an overlap, but...
Let me see whether any of my lords has a question, or my lady? No? Carry on. Let's leave you to take your course, because I appreciate you've only got another half hour.
Yes, and I want to keep... I've never exceeded my speaking time, and I don't want to do that now. We have taken the point about locus. Now, can I deal with this in this way? The board has in the authorities bundle section 39 of the Supreme Court of Judicature Act. This was the section which the Court of Appeal considered that it could rely on for the purposes of introducing on the appeal the doctrine of relation back. And it's at page 392 of the record of the authorities bundle, 392 in the electronic bundle.
When you said you were dealing with locus, I thought you meant the point about the proceedings being a nullity, but you're dealing with... No,
there is an overlap. Forgive me, my lady. There is an overlap, but I'm going to deal with... I am going to deal with the proceedings being a nullity, but I want to just deal with this because it relates to the same point. Okay, and I'm not going to... fear not, I'm not going to repeat the submissions I made about the doctrine. But Section 39, subsection 2, was the provision that the Court of Appeal relied upon to introduce the doctrine as against the appellant. And it's, I'm sure the board has heard the phrase, difficult to get a word in edgeways. The appellant's counsel in the Court of Appeal suffered from that very problem, because having gone to argue one issue, an issue which was good in law, that the respondent was not the tenant as the judge found, he was then confronted by what we say was not an uncomplicated point of law about the doctrine of relation back, which the judge had rejected. Was the judge right to reject it? Well, the Court of Appeal doesn't actually explain why the judge was wrong to reject it anywhere in its judgment, merely that they took a different view. We say that they exceeded their remit as a court of review, and in any event misuse Section 39.2. Because if the board looks at Section 39.2, you'll see in the second line, the powers of the Court of Appeal under this section may be exercised. So it gives the court a discretion. It doesn't have to exercise it, it may exercise it. And it then, in the third line from the bottom of the section, may make any order. And my lord, in exercising that discretion, if that is what they had wished to do, they needed to look at what happened in the court below and also take on board whether, in fact, a cross appeal had been filed. It's common ground none was filed. And although there is a discretion in subsection 2, in the modern practice of civil litigation where skeleton arguments, notice of appeal, all of these things have to be filed in advance, those were relevant factors to take into account before considering whether they ought to exercise their discretion under subsection 2. That it was discretionary does not appear to have been appreciated by the Court of Appeal, because just bear with me. If you look at page 282 of the record, we say that they misapplied the section, and it's at lines 40 to 45, Justice of Appeal Jamadar. So basically what it is saying, this is 39, that on an appeal you can set aside, vary an order, but what you can do is also make any order that the court could have made. Exactly, it is even broader, as my brother points out, that you could add and entertain new grounds. Now, we say, my lord, that that is not correct, because before the court could decide whether or not it was going to look at that issue, it needed to consider, 1, there was no notice of appeal, no cross appeal; 2, that there was no skeleton argument, which is now mandatory before the Court of Appeal where the point had been raised; and that 3, since the respondent was seeking to uphold the judgment purely on the basis that the respondent was a tenant, it was not an appropriate case for the court to exercise its discretion to introduce the doctrine in the way it did.
Well, why was there no application for an adjournment?
There are some counsel, my lady, who are much more robust and might be able to say, well, this is so unfair, I'd like an adjournment, I'd like to be able to deal with this later. There are other counsel who will do their best to deal with it on their feet and tried to deal with it, but didn't get, we would submit very respectfully, a fair hearing on the points they wished to raise. And in fact, he tried to refer to the fact that he had dealt with it in the submissions in the court below, but was not able to develop the submission in any significant way.
But you've gone back now to your first point, have you? That he was
It's the overlap.
unfairly, which I understand, but
well,
the lady said, now we're here to decide
of course.
the question.
And, but what we say is there's another point. This case comes before the board following a claim issued in February 2012. If that claim was a nullity, it would have been struck out. We say that that is the course that should have been taken and was in fact the submission made by the appellant in the trial court and also referred to in the Court of Appeal. And the reason I have referred to section 39.2 is because it relates directly to section 39.3, whereas the court had a discretion to exercise in 39.2. In section 39.3, the Court of Appeal in respect of an appeal shall not be restricted by reason of the fact that there's been no interlocutory appeal. So the mandatory language is used. They were bound to hear the argument that the claim was a nullity.
That's part and parcel of the whole question of relation back, isn't it?
It is, but this relates to the issue of the claim, because one of the points that was made by the appellant, both in its defence, and I'll give the board the reference, it's page 34 of the record. Page 34 of the record, paragraph 14, B and C. And as I say, I accept, my lady, there's an overlap. But they set out in their defence, pleading that the claimant had no locus, as well as that she had no letters of administration. They also reiterate the point at trial, and this is at page 190. Paragraph 16. So there can't be any doubt that they would have been entitled to develop this argument before the Court of Appeal, whereas the Court of Appeal took the view, as the board will have seen from the transcript, that, well, you didn't take a procedural appeal, therefore you can't raise it now. We say that was wrong and they were bound to hear it. And bearing in mind that the trial judge had rejected the doctrine of relation back, he didn't need to deal with the issue of nullity, it may have been thought, because he had ruled earlier on that I'm appointing her to represent the estate, albeit he made the appointment on the 27th of February, whereas the claim was issued in a representative capacity on I think the 1st of February.
Could you just give me the reference to the passage in Justice of Appeal Ramadar's judgment that you're now referring to?
Yes, just bear with me. So, should be. So I can take the board to
I thought what he
page
said in the
285.
judgment was that the relation back applied to the action as well. And
Yes,
that was the way he dealt with it.
that was Justice-
So the
Justice
question is
Appeal
whether that
Jones.
was correct or not.
Yeah. So if we go
That's,
to
sorry, that's line 35, I think, of page 287.
yes, I was going to say if we look at 283, sorry 282, to answer my Lady Arden's question. Bottom of page 282, lines 39. I've taken the board to that, and then the relation back.
I see. It does say after argument.
Right after that, yes, page 283. Mr. Dowlatt, line 29. So what is the nature of the point you want to take? You're saying that she had no locus to make this claim. Mr. Dowlatt, yes, my lord. And that, sorry, page 283, my lady. Line 30. This is the transcript from the Court of Appeal. And so Mr. Dowlatt, the appellant's counsel, indicated she had no locus to make the claim, indicated it was a point taken before, and then there's the discussion, as my Lord Leggatt mentioned, about whether the judge ruled on that, and then going over the page 284, which we would invite the board to specifically consider, lines 5 to 8. It appears that what has happened is that when the objection was taken by the appellant as the defendant in the trial, the judge went ahead and made the order. And that appears to be correct because there's no ruling on the point. And then a little later on, there's criticism of an appeal not being made on a procedural point. That's the interlocutory appeal. And then the judge saying at line 19, and the judge made an order curing the defect, basically appointing Angela Seeley, clothing her with the status to bring the action for the benefit of the state by court order. So that order, how do we impeach that now? Well, my lady, this is where we say, just pausing there, if notice of this point had been given and they knew they had to deal with it, the submissions may have been far more focused. And what we say is that had the court reviewed the procedure that had been adopted by the High Court, they may have found that it was unanswerable, that the claim was a nullity, and that the judge's order to appoint the respondent as a representative of the estate was bad in law. And the reason we say that is, and again, no dispute about it, the application was made pursuant to the Civil Proceedings Rules, Rule 21.4. And I would invite the board to look at that, which is at the Authorities Bundle, page 413.
Was this the argument of Mr. Dowlatt?
It was, well, he wasn't able to develop the argument because later on in the transcript, Justice of Appeal Barrow, how can you raise it now? And he's saying you can look at it now and doesn't get very far. But what we do know, and the reason I say this is important, is we've spoken about, and I hope I've answered the board's question in relation to the various options that the respondent could have taken to clothe herself with the authority to issue a valid notice. What she chose in the end was not to apply for letters, or she didn't apply for letters of administration, but more than that, for the claim, she then made an application pursuant to Rule 21.4, and this is at the board's record 413.
But you say this is prospective only and can't validate a claim which has already been brought.
Correct, but if my lady looks at the actual rule under which the application was made, there's a significant problem which leads to the nullity argument. Rule 21.4 is for the appointment of someone of a representative group. And I think what may have misled the courts below is that it starts with, this rule applies only to proceedings about the estate of someone who is dead. But then when you turn over the page and look at subsection 2, the court may appoint one or more persons to represent any person or class of persons who is or may be interested in or affected by the proceedings. So the machinery under which the respondent applied and the High Court acted to appoint her to represent the estate did not in fact allow her to represent the estate pursuant to this rule. It certainly could have allowed her, looking at the wording of the rule, to represent the class of persons who might be beneficiaries, but it would not and could not have acted as authority, as the Court of Appeal said, to clothe the respondent with authority to bring the claim.
The rule only applies to proceedings.
Indeed.
You have to have valid proceedings before the rule applies.
So, moving away from the doctrine, the locus point is simply this.
Sorry.
Sorry.
So are you saying that this only applies where somebody dies after they have already brought proceedings?
No. What I'm saying, my lady, is that this rule does not enable an appointment to represent an estate. It's not what the rule says. The rule may allow, looking at the wording of it, the appointment of a person to represent a class of persons, for example, the beneficiaries, but it doesn't act to allow the appointment of an administrator or anyone like it. And although we accept that the High Court, and it seems the Court of Appeal agreed, that is what the rule could have allowed, it doesn't. It clearly doesn't. So then we come to the authorities in relation to what can be done prior to the obtaining of letters of administration. Now, all of the arguments that we've made in relation to the doctrine about timing and when someone can apply and so forth, but surely if you're going to launch a claim, you know, and it is the law, that you've got to issue that claim with proper authority to do so. If you're going to say you are the representative of an estate, then you must be appointed in the appropriate way to do that. And if the board looks at how the story began, so to speak, which is page 4 of the record, you can see, forgive me, page 4 of the record, it's the claim form that was issued. You can see at the middle of the page, it was issued on the 1st of February as the representative of the estate of Cynthia Abbott. And then if the board turns to page 9 of the record, you'll see the endorsement in red at the top of the page when the judge ordered, or purported to order, on the 27th of February 2012, that she could then represent the estate. And quite apart from the fact that the rule did not enable the judge to make the order he did, we would resist any suggestion that the judge had the power to do it absent a proper application under a proper legal procedure.
But I'm not sure where this is getting to. I'm awfully sorry. I wonder if you could just help me. If there's no relation back, no ratification, then the proceedings were a nullity.
The doctrine of relation back, as a separate point, cannot validate the notices.
Why, if you win under that, you don't need this point. If you lose under that, you aren't helped by this point, are you?
I wonder whether we might be helped by this point if we lose under that, because if the claim is a nullity,
yes,
and should have been struck out, there wouldn't have been a trial, there wouldn't have been an appeal, and I wouldn't have the delight of appearing before the board. But that's why we've taken this point, because the Appellant's counsel did take this point that the claim was a nullity, and he did say it was so in the Court of Appeal. And whatever Rule 21.4 may provide, it didn't provide the machinery to appoint the respondent, and we say that we are supported in that by fairly recent learning from England at page 593, in the case of Milburn Snell. And it's paragraph 19, page 593. Where Lord Justice Rimmer, I think, cited with approval the extract from Williams, Mortimer and Sunnock's, third line in. However, it is not clear on what statutory authority an amendment in the latter case is permitted, and without such authority it is difficult to see how earlier authorities, Ingle included, can be ignored, particularly as they deal with substantive rather than procedural law. And we draw that to the board's attention because even the claim had to be brought by a proper person. And that...
I'm sorry.
I'm sorry.
I don't think we have Harkensing, do we?
Sorry?
We don't have Harkensing.
No, I don't think we do, but...
And it may be there are two Court of Appeal authorities on the same point, which would leave it open to a further Court of Appeal.
Yes, but it may not prevent me from developing this point, lady, because I want to conclude it. Because if the board then turns to page 598, which is the short judgment from the Master of the Rolls, Lord Newburger, dealing with the Ingle versus Moran principle, 4 lines down. However, whatever one's views of the value of the principle applied and approved in Ingle versus Moran, it is a well-established principle, and once one concludes that it has not been abrogated by the CPR Part 19.8, that's the English CPR, it was the judge's duty to follow it, as it is the duty of this court, at least in the absence of any powerful contrary reason. The need for consistency, clarity, and adherence to established principles is much greater than the avoidance of a technical rule, particularly one that has a discernible purpose, and these are the important words, namely to ensure that an action is brought by an appropriate claimant. And so we say, my lady, that that was an argument that the Court of Appeal, 1, was bound to hear, but 2, was bound to accept. Because at the time, as we've shown, the respondent issued this claim, it was a nullity, and it could not be cured by the order that the judge made, and certainly couldn't have been an effective order under the rule under which it was made.
And that helps you in relation to these proceedings, but the proceedings were not necessary for the tenancy to either revive or not. That would have happened regardless of these proceedings. So the nullity of these proceedings doesn't affect the question of whether the grant of the letters of administration did or did not validate the notice to renew the lease. It simply relates to the proceedings before the court.
I wouldn't concede that point, my lady, for this reason. Although I've argued that the doctrine doesn't apply to validate the notices, the procedure by which the respondent sought to seek the declaration that the lease was validated was by issue of this claim. And so if this claim had failed, and if it was a nullity, then the declarations or the findings of the courts below would also fall away.
But those declarations aren't what creates the renewed lease.
Well, she would still need, because it's a disputed issue, she would still need to prove that the lease was validly renewed. I don't think she could say, well, my claim is a nullity, if the board were to accept that, and then say, but the findings of the court that validated the notices survive. I don't think that can be right, because it was the disputed issue in the proceedings.
Could I ask you this point, and that is paragraph 35 of that decision, where the court went to some lengths to construct an appropriate order in relation to costs. And it's the point that my lady has been raising. Your client went into occupation of these premises in 2012.
Yes.
And if there was a valid notice to renew, even if these proceedings are a nullity, the administrator can immediately bring proceedings tomorrow.
Yes. But they would have to do that.
And those proceedings would be exactly the same, basically, as these present proceedings, and no limitation period has expired.
Well, my lord, if
your client went into occupation in 2012,
he went into occupation in 2012. I don't know without checking the limitation period. But what I can say to my lord is that it would certainly merit a further action to determine the issue.
I would like to be absolutely clear that the limitation period has not expired.
I will have an answer.
Over the lunch
absolutely. I will have an answer very shortly. It may be in the Limitation of Certain Actions Act that apply to land. I will check that and have the answer for the board after the short adjournment. But coming back to the nullity point,
can I just before you go on to that? As I understand it, you're saying that the relation back principle has application in certain limited circumstances, which you've taken as two, in relation to the issue we're partly concerned with here, which is the notice of renewal.
Yes.
Am I to understand that you're saying that the relation back principle has no application at all in relation to validating proceedings that are a nullity?
Your Lordship is right. And
even in a very narrow category, analogous perhaps to what you've already said in relation to where it could conceivably apply. So what is that your submission?
It is, and I was about to take my lord to the relevant, we say, established approach to that, which is at page 536, the case of Ingle versus Moran. Relying on the board's decision, fairly well known, of Chetty and Chetty, as to the limits of an administrator's powers, top of the page, page 536 in the authorities bundle. Third line in, if any authority for this is required, it can be found in the judgment of Lord Parker in Chetty and Chetty. An administrator is, of course, in a different position, for his title to sue depends solely on the grant of administration. And then it's true that when a grant of administration is made and the testate's estate, including all choses in action, vests in the person to whom the grant is made, and the title thereto relates back to the date of the intestate's death. But, I hope this answers my Lord Borough's question, but there is no doubt that both at common law and in equity, in order to maintain an action, the plaintiff must have a cause of action vested in him as at the date of the issue of the writ. And then if the board turns to the very next page, further part of the judgment, and it's the bottom of the page that's perhaps the most important. Sorry, halfway down the page, the words, I have no doubt, 10 minutes, 5 minutes. I have no doubt that the plaintiff's action was incompetent at the date when the writ was issued, and that the doctrine of relation back of an administrator's title to his intestate's property to the date of the intestate's death, when the grant has been obtained, cannot be invoked as to render an action competent which was incompetent when the writ was issued. In my judgment, the learned judge was wrong in coming to the contrary conclusion. It follows that no proper action was commenced before the statutory period of limitation expired. That period expired before any grant of the administration was obtained, and the right of action was lost to the intestate's estate.
Well, in the passages in the authority from Williams and Sunnock's current edition, there's reference to Foster and Bates and other cases where the administrator could bring an action in trespass even before he was appointed.
Yes, but the trespass, when is that trespass? And in this case, it seems that the respondent issued the proceedings in 2012 because she considered that after the expiry of the lease, the landlord still had no right because she had renewed the lease. It's somewhat a circular argument, but that appears to be the approach she adopted. If we are right that she hadn't validly renewed the lease, then her action in trespass would have failed, and the board would have seen that the judge took the view that only nominal damages would be appropriate anyway because there was minimal entry onto the property.
Well, but so you seem to be accepting there that there can be an action in trespass by somebody who has not yet got the letters of administration granted. So that, I think, was what my Lord Burrows was asking, whether there's any exception to this apparently very strict rule in Ingle and Moran in relation to a trespass onto the property.
Well, my lady, in relation to taking action to protect the estate, such action would include protecting the estate from a trespass by a particular person. It's somewhat unusual facts. We come back to the facts, but in this case, because we have said that the notice did not validly renew the lease, there is no trespass. A man cannot trespass on his own property.
Assuming that there is a trespass in a different case, do you or do you not accept that the potential but not actual administrator can bring an action in the name of the...
If there's a trespass during the currency of the lease, then yes, a person can bring an action to protect the estate from injury, and I think that some of the cases relate to that. However, the additional factor is whether it is objectively beneficial to the estate to do so. And so perhaps an example might be this. If there has been a trespass on the last day of the lease, even though there may have been a trespass, it may not be...
Using two concepts. Yeah. That is, an administrator, once appointed, can sue for a cause of action that arose before the death of the deceased. Yes. And the administrator can sue for a cause of action that accrued in the interval between the death and being appointed, the administrator being appointed. But the question that is being asked is whether the potential administrator can sue without letters of administration or without a limited grant or without a receiver being appointed, can actually bring proceedings that are valid.
To repel a trespasser.
To repel a trespasser.
Prior to letters of administration being granted. That's right. I think the law does permit that to occur, acting to protect the estate, but that action also has to be of benefit to the estate. And
where's the authority for that proposition?
I'll show it to my lord. But if I can finish the argument and then take my lord to it.
We've got to 12:30, so you'll have to wrap up pretty.
Yes.
You have got a very extensive written submission.
Yes. What we say is that the objective benefit, if I can answer my Lord Stevens.
Of course you must.
If you have a situation where somebody trespasses on the last day on a property and then the lease expires.
It's the cause of action that accrued.
Although that is the cause of action that has accrued, yep. And you could potentially take an action to repel that, because of the trespass. The other question then is, does that objectively benefit the estate? And since the lease has expired and the trespass is minimal, it might be said objectively, and we would say, it doesn't objectively benefit the estate.
And that seems to me to collapse back into the issues we had before. I mean, I asked a specific question.
Yes.
Were you saying there were no exceptions? And I understood your answer to that to be, yes, there are. In fact, as it's now gone on, we're back into exactly the same questions that we had before, it seems to me, both for the renewal of the lease and for the nullity of the proceedings. It seems to boil down to the same basic question about relation back.
Well, we wouldn't say it is, because the way in which the courts have dealt with this, and if I can just give the board the references, because I know I'm out of time. Right, yeah. We've got the case of Chetty and Chetty, but the case of Ingle versus Moran that says that the doctrine doesn't have application to the validating of the proceedings, as opposed to what we're talking about, the subject matter, is at page 540, middle of the page, where Lord Justice Goddard said this: nor is it necessary to consider the many cases which show that once letters are granted, the title of administrator relates back to the death. They have no application to this question. And then goes on, may sue in respect of a cause of action, my Lord Stephen's point, that had accrued to the estate before his death, provided the cause of action survives. The result is that the action was and always remained incompetent, and the judgment ought to have been entered for the defendant, because at this time, coming back to our case, that didn't happen. And the point is underscored in the cases from Trinidad. I just give the board the references. Is Archibald versus Camacho, page 555, making the same point that the doctrine of relation back cannot in such a case be invoked to render competent an action which was incompetent when the writ was issued. And the case, more recent case of Abraham, accepted the principle that Ingler Moran is good law, and I'll give the board the references. It's page 564, paragraph 24, page 565, paragraph 27, citing with approval Milburn Snell, 28, and paragraph 28. And then a more recent case from the Court of Appeal, again having considered the English cases. This is the case of Sanker, and it's page 583, paragraph 27. Therefore, to my mind, the general principle that remains that proceedings commence in a representative capacity without the necessary grant are a nullity and cannot be cured by a subsequent grant or appointment. So the doctrine has nothing to do with that question. It's a simple matter of have you got authority to bring the proceedings? And as we've illustrated, we say that both on the doctrine we are correct, but also in relation to the issue of the claim, it was a nullity, as was argued below. Milady, I think I'm just over. Can I assist the board further? And I'm going to come back to my Lord Stephen's question about limitation.
Yes, indeed, you said we'd do that later. Thank you very much. Mr. McQuilkin, would you like to make your submissions? We can hear you.
Yes, please, lady. As long
can
as
I just check whether... just let me check everyone can hear you. No. Could you just allow us to see whether we can get any technical help to increase the volume?
Certainly, my lady.
Thank you. Just a moment. I'm sorry about this. It'll take a moment.
Milady, I'm being asked by technical persons to say a few words in hope that that could assist.
It's helpful for you to just experiment, but at the moment, not all the members of the panel are hearing you, and it's important that everything is heard by all the panel. So if you can just give us a moment, there's some technical help coming to see if we...
But Milady, the point I was making is that I received a message from the technical persons for me to speak, to see whether or not that could assist them in their technical...
yes. Is it possible for you to speak nearer the microphone of your laptop? That might make a difference.
That's okay now.
Ooh, careful.
I've moved the microphone closer, my lady.
That's better.
That is better.
Are you all happy to proceed?
Yes.
Thank you very much indeed.
We're happy to proceed. Thank you. That's resolved it. We'll let you know if there's any problem. I'll ask my colleagues to let me know.
I'm indeed grateful, my lady. So my lady, might I begin firstly by expressing my gratitude to the board, of course, to allow me to appear in this way. We know, of course, that this appears to be somewhat of the new normal, but I'm indeed grateful and wish to express my gratitude for that. But indeed, my friends from the Appellant essentially raised three issues on this appeal. And as my learned friend has taken the board through, in terms of those three issues, I can describe them very broadly as the Section 39 issue, which relates to the introduction of the doctrine by their lordships in the Court of Appeal. That would be the first issue. The second, of course, would be the applicability of the doctrine to this present case. And the third issue, which I don't believe that my friend had an opportunity to address orally, but which is raised in his written arguments, nevertheless, is the issue of leave, and whether or not the Court of Appeal was correct in refusing leave to the appellant. So that if I could take essentially the indication that was given by the board to my friend, I can start with the second issue, which is the applicability of the doctrine to this present case. And I think it's important, before proceeding with the law, that I think that I should simply, at this particular point in time, mention some certain aspects as it relates to the facts of the case. So that, as my friend has already has already quite helpfully indicated to the board, we do know that this particular claim involves essentially a tenancy of Cynthia Abbott, which began in 1949, and which, pursuant to the Security of Land Tenure Act, have been converted into a statutory tenancy by 1981. Ms. Abbott then died intestate, as we know, in 2006. And the former landlord of the property, which would have been the appellant's father, also died in 2007. But before he died, he passed the property on to the appellant and to two of his siblings, and therefore they then became the landlords. This would have been shortly after the death of Ms. Abbott. And it does appear from the facts of the case that the respondent was not aware of that, because in particular, when we look at the page 111 of the bundle, there is a letter which is written by the respondent's attorneys at law, asking the appellant essentially to obtain a grant of representation to assist her in terms of purchasing the property. Now, the reason why I mention that particular letter is because my learned friend for the appellant makes the point as it relates to the doctrine of relating back, that the respondent, essentially intended to obtain the property for herself. In other words, he says that that was the evidence before the trial judge. Now, respectfully, we of course take a different view as it relates to whether or not that was in fact the evidence. And what we say respectfully is that what can be gleaned at page 111 of the electronic bundle, and this is in fact the evidence of the respondent at the trial. And in particular, it's paragraph 10 of the respondent's evidence, where she indicated specifically that after the passing of her mother, and if the board would permit me to read, after the passing of her mother on or about the 9th of February, together with her siblings, Wilma Horn and Osden Abbott. Now I pause here simply to indicate that Mr. Osden Abbott, who is referred to here, is in fact the co-administrator, so that the evidence before the court, which the trial judge accepted, because of course he does not dispute it and he doesn't say anything in terms of whether or not he did not accept it, but nevertheless, which the trial judge accepted. In particular, Mr. Abbott is in fact the co-administrator, and what the respondent is saying is that together with the co-administrator and another sibling, they approached the appellant with the intention of purchasing the property together. So that there was no intention, the point that I'm making is essentially that there was no intention by the respondent, as my little friend has suggested, that she was simply going to purchase the property for herself. There was a clear intention which was signaled by her that the intention was to purchase the property on behalf of all of the siblings. Now, there is, of course, and my learned friend is correct in referring to the letter which was written by the respondent's attorneys at law. And that letter can be found at, just permit me, at 135 of the record. And this is a letter dated the 4th of November, 2011. And essentially, this was a letter which was written by the respondent, indicating the intention to purchase the property, of course, pursuant to the Land Tenant Security of Tenure Act. This is where it was indicated. And it appears as if what my learned friends have done is to say that simply because of the fact that this letter appears to have been written by the respondent's attorneys at law, on her behalf as a legal personal representative, that this should be construed as an intention by the respondent simply to purchase the property for herself. And what we say respectfully is that that's not the case. Now, the only reason why I mention all of this is simply to say, and as I think that the board has indicated to my learned friend, that as it relates to the doctrine of relating back, there is in fact no objective assessment that requires an assessment of the intention of the administrator and or the persons who attempt to protect the estate by way of either the service of a notice or by way of an action. That's not part of the objective assessment. And I intend to make that particular submission by taking the board to the extracts that we have provided from the Williams, Mortimer, and Sonnets. And that is at page 426 of the electronic bundle. That's where I'll begin. And I think that when I get to page 427, it will answer a question that was also asked of my learned friend as it related to exceptions to the general principle of relating back as it relates to proceedings. But if I could begin, firstly at page 426 of the electronic bundle. And if the board would permit me to read, the extract from the Mortimer at paragraph 510, that's the paragraph where I'll start, it says, as set out above, an executor may carry out most of the acts relating to his office before probate. However, for an administrator, the general rule is that a party entitled to a grant of administration can do nothing as administrator before obtaining a grant. This is because he derives his authority entirely from the appointment by the court. Before this, the deceased's property vests in the public trustee after appointment. An administrator has the same rights and liabilities and is accountable as if he were the executor. And it continues. And if the board would permit me to read, to continue to read. By reason of the general rule referred to above, a person has no right to commence proceedings as an administrator before letters of administration are issued, or until such time he has no right of action. Under existing case law, the subsequent issue of the letters of administration will not assist, for the grant is not for this purpose relayed back. However, the Court of Appeal held in Melbourne, Snell and Evans has now held that proceedings commenced purportedly on behalf of an intestate estate, but without a grant of administration are an incurable nullity. In so holding, the Court of Appeal found that such proceedings cannot be validated by direction under CPR 19.81. This is the exception, and this is the answer to the question that was asked of my friend. And I think that my friend also accepted that another exception would be in the case of trespass, a claim for trespass. An exception to the general principle, and I'm now over the page on 427, an exception to the above general principle exists where it is necessary for the person who is entitled to the grants of letters of administration to take possession of the deceased's property to safeguard the estate. He has an immediate right to possession enforceable by action. So that's the exception which was asked of my learned friend. And if I may, just to take the board to page 429.
Well, before leaving that page, the authority quoted is footnote 73, Caudle, yes, Caudle against LD law. And the, as far as I can recollect, Ingram and Moran wasn't cited in that case, and the comments were obiter.
Yes, my lord is correct, and that particular authority, it forms part of the record at page 497, and it's cited by us as well as part of our written arguments.
Are there any other authorities in support of the proposition in support of that proposition, an exception to the above principle exists? Are there any other authorities of which you're aware?
Not that I could put my hand on. This is the only exception that I have found by reference to the text, and as it relates to the cases as well. I could, if I could assist the board, attempt to see whether or not there are any other authorities.
Yeah, thank you.
And I was about to take the board over to page 429. And if the board would permit me to read under the rubric relation back for the benefit of the estate. And this is to make good the point that there is no, the objective assessment does not include an assessment of whether or not the successors in title have an intention to deal with the estate in a particular way. Because it appears that that's the submission that my learned friend for the appellant is making. The general proposition, and if the board permit me to read, that letters of administration do not relate back to the date of death is subject to a number of exceptions or apparent exceptions, which apply by statute or at common law, where this is for the benefit of the estate, simpliciter, which is indicated. The test is objective. That is to say, the grant relate back only if this actually benefits the estate and not because the expected administrator thinks it will benefit the estate. Although there is no authority on the question, it is thought that the test of benefit must be at the date of the act in question, regardless of supervening events. So that just simply applying that particular extract to the facts of the case, it means that the objective assessment as to whether or not it's done for the benefit of the estate begins with an analysis of the action that was performed by the respondent on the particular date. And that particular date that we're referring to would have been the service of the notice of renewal. At that particular point in time, and as we know from the agreed facts, that the notice, and as accepted by the appellant, that the notice of renewal was in fact served on the 12th of January 2011, and therefore the lease was still subsisting in the estate of the deceased at that particular point in time. The lease had not come to an end. So that the actions which were done by the respondent as of that particular date, objectively say, in attempting to, or as we say correctly so, in extending the lease, what we say respectfully is that it was done for the benefit of the estate simply because of the fact that the estate, what vests in terms of the estate of the deceased, Ms. Abbott, at the point in time, would have been her leasehold interest, which was created by the Land Tenants and Security Tenure Act as at the commencement date in June of 1981. So that objectively, what we say respectfully, is that objectively, looking at the actions of the respondent at the point in time, we say that that should lead ultimately to the construction that it was done for the benefit of the estate. The intention, whether or not there was an intention for her as a beneficiary to pass the interest in the property on to her son and on to her other children, whether or not there may have been any agreement between the beneficiaries as it relates to dealing with the estate of their mother, we say respectfully that that's not relevant. That's what we say respectfully, as we've said in our written case, and we simply wish to underscore that particular point in our oral submission. The effect of it is that what we say respectfully is that the doctrine of relating back would apply when the respondent effectively issued the notice which the appellant accepts as being served, and that the effect of that would have been to renew the statutory tenancy for another 30 years. Now my friends to the appellant say ultimately that the respondent was not the proper person at the point in time to serve the notice, and in fact addresses the board as it relates to a formulation that would require the respondent, after receiving letters of administration, to somehow clothe herself with the title of tenant before issuing the notice. And what we say respectfully is that that's not the intention. And my Arden, I believe, would have asked the question, and just simply to answer that particular question as it relates to the tenancy being for the benefit of the successors and assigners and or successors in title. That reference, we say respectfully, can be found at the electronic bundle, page 608.
(648).
608.
Sorry, pardon me.
So, yes, 608.
I got it wrong.
And that's in reference, and that's the authority of Carl Hector and Oliver Keith. And in particular, I wish to refer the board to page 612 of that electronic bundle. So it would be 612 and 613. And in particular, it's essentially what I wish to refer to the board. It's essentially paragraphs 16 to 19 of the decision of the Court of Appeal, and in particular, the decision of Mr. Justice of Appeal Mendonça. And in it, at paragraph 16, he says that the clear intention of the act, and if the board will permit me to read, that the clear intention of the act, and the act that he's referring to here is in fact the Land Tenant Security of Tenure Act, is to vest in the statutory tenant a leasehold interest in land capable of being assigned inter vivos and capable also of being transmitted by will or on intestacy. This is obvious from the provisions of the act. First, there is a provision of the Act already alluded to that converts a tenancy to which the Act applies to a statutory lease for 30 years. This is clearly an interest in land and not merely a right in personam. There is no indication in the Act that such an interest cannot be assigned or that it does not pass on the death of the tenant. On the contrary, there is section 5.8 that specifically speaks of assignment by the tenant. Section 5.8 is as follows, and Mr. Justice of Appeal Mendonça repeats it here. that a tenant has the right to assign or sublet with the consent of the landlord, whose consent shall not be unreasonably withheld, but the rent payable by any subtenant shall not exceed the rent payable by the tenant to the landlord under this act. There is also, he continues to say, Section 6, which refers to the option for renewal of the lease conferred by the Act on a tenant. This section makes specific provisions that the rights and obligations of the tenant arising from a notice of renewal shall endure for the benefit of and be enforceable against the landlord's executors, administrators, and assigns. If the option for renewal endures for the benefit of the tenant's executors, administrators, and assigns, there is no logical reason why the original lease should also not be for the benefit of the tenant's executors, administrators, and assigns. And he goes and over the page at paragraph 18, Mr. Justice of Appeal Mendonça continues that there is also the definition of a tenant in the Act, and he repeats the definition of the tenant. This definition, and I will not trouble the board with that. This definition expressly refers to the interest of the tenant being acquired by assignment, and is also wide enough in its contemplations to refer to persons acquiring an interest on the death of the original tenant. I do not think, and this is the last paragraph, I do not think that there can be any doubt that the Act gives to the tenant an interest in land capable of being transmitted on the death of the tenant. The interest of the deceased in the parcel of land therefore did not cease on her death, but became vested after her death in the respondent. Counsel for the appellant is, of course, in the course of his argument, did not really press this point, and it's fair to say that it was conceded by him. So effectively, the submission that we make, respectfully, is that upon the death of Ms. Abbott, the statutory tenancy would have vested in her estate, and therefore the actions of the respondent thereafter in renewing the lease were in fact for the benefit of that estate, and not to make the circular argument or to remake the submission. But that's and effectively what we say is that the intention and or any intention that the appellant says should be construed in terms of the respondent, whatever the respondent chose to do with her interest in the property, has absolutely no bearing at all on the application of the doctrine. And respectfully, just to conclude that particular point, we simply wish to refer the board to the case of Morgan and Thomas, which is in terms of the electronic bundle, this is simply just to underscore the point of the objective assessment, which is starts at page 605 of the electronic bundle. And in particular, at page 606 of the electronic bundle, in the case of Morgan and Thomas, and in particular, the decision of Pollock, which is about the bottom of the page of 606. And if the board would permit me to read, it's about the bottom of the page, and if the board would just permit me. The extract of the case, I'm trying to assist the board and take you directly to where the
exactly.
particular.
That's very helpful. We've got it. The Chief Baron is saying that the relation back gives effect to what he had done by way of anticipation.
By way of anticipation, yes, precisely.
Good. Is that a convenient place? Is that all you need from Morgan?
The other reference from Morgan is in fact from Barron Park. and that is at page 607 of the bundle. And if the board would permit me to read, an act done by a party who afterwards becomes administrator to the prejudice of the estate is not made good by the subsequent administration. It is only in those cases where the act is done for the benefit of the estate that relation back exists, by virtue of which relation the administrator is enabled to recover against such persons as have interfered with the estate and thereby prevented from being prejudiced and despoiled. So those are the two references.
Thank you. So the answer to my Lord Stevens is that there is more authority than is cited in the footnotes to Williams, bearing out the principle of benefit to the estate, and that being a basis on which relation back can operate.
Yes, precisely, and that's the simple point that we wish to make.
Indeed. Is that a convenient moment now? I think we'll rise.
Yes, I believe it is a convenient moment.
Thank you. 2 o'clock.